There is. This all counts for our duties, right?
Yes.
All of it counts.
And then they asked me to come back. That was number 2. Then I retired again.
Alex,
They asked me to come back
can you hear
again.
These-
I can hear you. Can you hear me?
I can hear you. That's excellent. Great. That's awesome.
Jen, you try talking.
Jen, you try talking.
Hey, Alice,
Okay. Also hear her well. Okay.
is this a business?
Okay, awesome. Okay, so you can like either
Is it a
black
business?
out or do
Oh,
it
no, it's just-
or whatever you're comfortable doing.
It just asked me.
Me back to attendees.
Okay,
Deborah.
I will do that.
Yeah, so they're like, this is what this is. Yeah, like that too.
Yeah. And you'll get
It's off, it's playing game. This week I realized how much work was on here.
Oh, God.
So, yeah.
Yeah, we just got off we were at the Tampa meeting. How to get that.
Yeah.
No, we had a virtual meeting with them, just trying to set up, they want to do like internships and that stuff. The Tampa Museum of Art.
COP.
Yeah.
So already we're.
I don't know if I'm gonna do it.
Can you hear us?
Yeah.
Okay.
Here, I'll go check this a second.
Yeah.
And then.
No, I just don't wanna keep flipping it.
Can you
So-
hear Monica? Can you hear us?
Hello, hello.
Okay, that's good. I hear your voice. That's what I wanted to make sure you were coming through.
Can you hear me?
Yes.
Yes, yes, I can hear you first. Oh, okay.
So
I'm gonna go into a different system.
I would have gotten it if it was over here.
It doesn't sing anymore.
I see, I do the desk with somebody.
I'm gonna go check.
She's doing crying
If I can go in the back end, I just gotta go.
And do you live locally?
Well, I'll be here till.
Not that local, I live in Laurel Oak, which is up Sea Ridge, yeah.
That we don't have to bug you.
Well, it's nice to meet you. I'm sure you're kind of a learning curve. All the committee stuff.
I actually have been on the Board of Obstetric Medicine.
I think I typed something on maybe too. Let me see.
Oh, brilliant, okay.
So that now.
Yeah. And then whenever you say-
just in
So I'm not
And then,
totally, although it's a little more bureaucratic.
Sydney, you want some water? You
Oh,
okay?
I'm okay.
Deborah, do you need some water?
Oh, is it?
Sure.
Yeah.
I just wanna, which one do you think I need to do?
You're on the government.
Yeah.
That's right. We'll watch with that.
No, 15, 300.
Just briefly, hello, Sue.
And soon we're.
You get, yeah, you get half.
You and Sue are what?
We
And you
were
get
in
the
the same.
tumbler, and you get the license plate.
Oh,
Years ago.
yeah, alumni, wow, that's really.
Well, no, it didn't, this is
So
a whole different
Oh,
stuff there. I just, but you said you wanted to use a different one. Okay, which,
Well, it's.
I'm just, I don't want to keep looking at, so I'm just gonna touch on that one. And then do you want athletic general fund? That goes to anything. Yeah, that's like.
Assuming.
Okay, and then I'm putting Robert J. Murphy, right?
Even if it was only a golf team. you know,
Okay.
Okay, there's another one.
Yeah.
And they've done that since the start, so it's good that this is a full, a real start.
Yeah.
Yeah. And sometimes it depends on the personality of the student at the time. Like one student, he was just a first major started growing team.
6, 5, 7,
And
Oh, if then this is, how natural is that?
isn't that brilliant?
Yeah.
Yeah. And it's a fun to watch. And then in about 10, another student, who was president of student government, started the sailing team, which is perfect, like we have a boat.
he's a alum too.
They both take a lot of money for the equipment.
Yeah.
But I think they get a lot of, they did get a lot of, and he should be down person.
Yeah.
We got checks for him to sign, so I'm like,
You
have to grab it when you can, because he's not gonna get a hold of it.
But here's the
You're parking on someone's
project.
I was thinking people were used to that.
Oh, yeah.
Especially now that you can't park on the grass. It's really,
I had one, had him around,
Hi.
the function.
Okay,
Nice meeting. you.
I know what I did wrong. I saw, I think I did the. I don't think it went, but it's okay. And then, what's what?
Yeah, when it's like no progress, no progress, no progress, then all of a sudden they have like the whole last thing up.
That's right. That's right.
Thinking it's the Legos.
Yeah, he's gonna,
Like,
see, that's why the other ones in Ghost.
Oh.
I just love the,
Yeah,
There you go. Okay, so
My
I'm gonna go back.
sons love that.
I try to get there.
Here, right here.
But
This is why. Yeah, it's not just one through, because I didn't do it, right.
beginning
Yeah.
around the 4th of July. Now I head back for 10 days after our board meeting.
Oh, yeah.
It's easy,
good.
Tampa direct. Now.
Yeah, yeah, I mean, that's part of the reason why she found these people. And they.
I'm gonna go check on that.
I have questions.
After you're done, get all your merch from Alex.
Hello,
Oh, is
Jim.
that in the book that?
I'll tell her, she's great, she's right there.
Jim, can you hear us okay?
I can. Hello, everybody.
Awesome.
Hi, Jim.
So glad you can hear. Thank you.
Yeah, I'll see you later.
Yeah. Yeah, just leave up the little one.
Short.
Oh,
that's
you know what?
good,
I
Deb.
swapped
That way they
mine.
can
I
see
swapped-
you. So I'm
swapped
glad
these.
you moved over. Thank you.
You're even shorter, I think. Here we go.
There we go. That's better. Okay, Rob. Rob. I'm not sure who that
I think
iPhone
that's
is.
JJ.
It is? Okay. That's always the hard part. Oh, no, it's phone number. Yeah. Oh, that's. Yeah, yeah, well, there's so long, we can keep wondering.
We should get together off.
Yeah.
Time and just talk about.
Who's the iPhone? There's no name.
I can put myself in marketing ability.
Absolutely.
Mike Ron, he's the chair of the manatee.
Yeah.
I just.
Yeah, Mike Ron's here.
Hey.
I'm having to jump onto my phone. I'm trying to get it into my computer, but I'm on my phone right now.
Okay, that's fine.
I think.
Yeah.
Hi, Ron, it's Monica.
Hey, Monica, how are you?
How are
Long time no
you?
see.
Yes, I had a long talk with Renee today and I told her the other day to say hello.
Yes, ma'am. Well, good to see you.
Good to see you.
Yeah, with the excitement.
Yeah. I think it's not a full house. Yeah. I look forward to working.
There's JJ.
Susan, since we have some new faces, maybe we'll go around and do a quick self-introduction.
So Susan will do that.
Well,
I think
yeah.
you and Mike are the newest,
Yeah,
right?
yeah, we were both in it.
Actually, Deborah should know.
Yeah, they're the newest of the.
What's the current
What's
count?
the total of board members right now? That's okay.
Hello.
Should we start?
Okay, I'm gonna call the meeting to order. Katrina, can you do the roll call, please?
Of course. Make sure you let us know if you can't hear, those of you who are virtual. Deb James.
Here.
Adam Kendall.
Here.
Susan Burns.
Here.
AJ Jansen.
Here,
Mike Ron.
Here.
Christy Fitzpatrick.
Here.
Rob Balad.
Here.
Hazel Bradford.
Here.
Jim McDonald.
I'm here.
JJ Miranda.
Here.
And Monica Van Buskirk.
Here.
We have a full group today and definitely a quorum. And the meeting was definitely noticed within the correct time limits.
Well, it's fantastic. We have a full house, so thank you everybody for attending. I want to welcome our brand new members, Mike Ron and AJ Jansen. And so
Recording
I'd
in
like everybody
progress.
to go around and introduce themselves, starting with AJ and Mike. Just tell us who you are and why you're interested in New College in a sentence or two.
so I'm AJ Jansen and I live in Sarasota. I have been with the blood bank. My previous board was the Board of Osteopathic Medicine. I have a medical background, but I have very heavy sales and marketing background as well. So when New College is right at my back door, it's in my community. And I've always been interested in New College, visiting the Ringling and all, but with the changes that are happening, especially the sports teams, I think that's really great because that builds loyalty, camaraderie, and I think this is a great place to be going forward in point of my life. So I'm here to help. And I hope we have a very successful board going forward in the next year.
Welcome, thank you.
Thank you.
Mike?
Hi, I'm Mike Ron. I am the current chairman of the Manatee County Commission and the District 4 Commissioner, and a lot of new colleges in my district. And being that I've been born and raised here, I've watched New College evolve to where it is today. And my past life in philanthropic, I'm the past chair of the Safe Children's Coalition, and was there for since it started, since it became the Safe Children's Coalition. So just very active in the community, and want to, help New College grow and grow into the great college it can be, and it will be at some point.
Well, welcome and thank you for coming on board. I'd like to go, starting from the left-hand corner. I hope everybody is seeing the same screen that I am. That would be you, Monica. And let's just go around and introduce ourselves, and then we'll do around the table. Monica?
Hello, I'm Monica Van Buskirk, and I'm pleased to be on this board. I've been active in New College on the board and as a consultant for over 6 years. I'm on 2 other boards, and I'm going to join another board in September. And I'm grateful for a group of volunteers that work very hard.
Thank you, Monica. Jim?
Hi, I'm Jim McDonald. I'm a New College alum, graduated in 1981. Now I'm an employment lawyer with the national law firm of Fisher & Phillips. I have an office in Sarasota, in Tampa, and Southern California, where I happen to be today. But most of my focus now is on Southwest Florida, and joined the board earlier this year, and thrilled to be a part of the foundation, and hoping to raise some money.
Rob?
Hi, I'm Rob Balott. I'm also a New College grad from 1983. I'm an attorney. I live up in Cincinnati and part-time down in Sarasota on other boards as well, and joined the board here just recently. Had been on the alumni board before that, so I'm happy to continue helping out the school. Thanks.
JJ?
Good afternoon. I'm JJ Miranda. Been on the board, I don't know, a couple months, 2 or 3 months. I was a past board member for the college itself, or New College, appointed by one of our governors. My connectivity to New College is my daughter graduating, and she's a fabulous Manatee resident at Bradenton Christian School, teaching all those high school kids art, where she received a great education, and I'm excited to be involved. I'm a banker by trade. Nope, I did not charge you fees. It's not my fault. Thank you.
Christy?
Hi, good afternoon. Christy Fitzpatrick. I work at New College of Florida, so I serve in a couple of different roles. So I'm chief of staff here and also serve as CFO for the college, and representative for President Corcoran on this board. Thank you.
Hi, I'm Deborah Jenks. I graduated from New College in 1980. I am on the Board of Trustees of New College of Florida, and I'm currently the chair of that board. So I have a seat here on the foundation board. Thank you.
Thank you.
Hazel. Okay, go again.
Hazel.
I'm Hazel Bradford. I entered in 75, which is how we used to say it. And served many terms, term limited on the Alumni Association. So I've always been a passionate believer, and I still am.
Thank you.
Hi, Adam Kendall. I am a graduate of New College 2002, spent 5 years on the Alumni Association board, the current chair of this foundation. Professionally, I've spent 24 years at Morgan Stanley as a senior portfolio manager and certified financial.
Katrina?
Oh, hi, I'm Katrina. So I know you all know me because I reach out to all of you all the time, but I'm very blessed to work with all of you. You are all such a professional, wonderful group of people. And I've been here a little over a year. So I feel like I'm a lot better at running this machine now than I was this time last year. So I'm very grateful. So thank you, Susan. I appreciate that.
Susan Burns, this is my 4th year on the board. I'm the chair of the governance committee. I graduated from New College in 1980 and had served brief time on the alumni board. And my former life was editor-in-chief at Sarasota Magazine. And I'm very passionate about New College. David.
Dave Brickhouse, I'm the Vice President for Legal Affairs at New College of Florida, and I serve as legal counsel for the foundation and its committees.
Let's see.
Hello, everyone. I'm not on camera. There we go. I'm Sydney Gruters. I'm the VP of advancement here at the foundation. I thank all of you for your time. I know I get paid to be here. You don't. So please know how much we appreciate you volunteering. And I know it's out of passion to make this a great place and to fundraise to support our students. So thank you.
Thank you, Cindy. Okay, so I want to thank everybody again for attending this meeting, and especially because we've got everybody here, and especially because the topic is bylaw revisions, which are pretty tedious. I want to give a special thanks to Jim. Jim volunteered to begin the draft of our bylaw revisions, so thank you very much, Jim. And then I know that it went to David to look over to make sure we are in legal compliance. And then I think the two of you worked together. And I think it was, obviously, you worked quite a lot of time because there's a lot of revisions. It looks like you went line by line. It was very thorough. We are supposed to revise our bylaws every 3 years. We are a year overdue because of all the changes. So this is an important revision that we're looking at right now, especially because we've had so many changes. So while this feels like it might be kind of tedious, it's really important for us to take our time and be patient as we go through this process. I think the best way to do this is to go page by page. We'll start with each article. And if you have a comment on any of these articles and sections, just raise your hand or speak up, and we can talk about any of your questions or concerns. You can also make a motion if there's something you want to add or change or omit. I don't know if omissions require a motion. David, do they? Do omissions?
I think it would be couched as a motion to amend.
Amend, okay.
Yeah.
So we could do that at the same time. Let's just start. We've got a lot to get through. So does anybody have any general comments to begin with?
If I could just start and give some context to the work that Jim and I did in doing an initial review of the bylaws and what revisions we felt were appropriate. And so beginning of that, there were some just technical or what I call nit changes of defined terms and different things. And that comprises a large number of the changes that you'll see. So it looks like a lot more than it may actually be. But we also started and just took two of the preeminent universities in the state university system, being University of Florida and University of South Florida, and took their bylaws for their foundation as a DSO and looked at those provisions. And I would say almost all of the changes and language that was added or subtracted from our bylaws in this proposed draft came directly from the language from either UF or USF, and just trying to bring ourselves to that standard and make it comparable to what our other sister institutions have as kind of best practices and what they've done over the years. And so I just wanted to kind of provide that context of where these changes came from. And so if there's any questions along the way, Jim and I would be happy to answer anything from that regard.
Thank you, David. All right, let's look at page 1. Does anybody have any questions or observations about page 1? This would be Article 1, 2, 3, and 4.
I have a quick question. Why was it changed from corporation to foundation? Does that matter? Is that what UF and USF?
Well, it is, but so it was originally defined as both foundation or corporation. So it was used inconsistently throughout the document. So It's just kind of best practice in legal drafting to pick a defined term and then stick with it. Doesn't change anything. Yeah.
Rob?
This is a spoiler alert. This is my only question because I've gone through all of it, and most of it I think is fairly self-explanatory. But the part that I'm sort of struggling with understanding how this works is it's first time it's referenced is Article 4, and it's the ex-officio directors. I'm just confused, frankly, about how many of these people, what their status is, what the difference is between an elected director. For example, the very first section here, Section 1 in Article 4, says, the board should have at least 12, but not more than 24. But that does not include ex officio directors, which means we could have technically 1,000 people on the board. And then you've got, and I know I'm leaping ahead, but then I was trying to figure out, where do the ex officio folks come from? How many are those? I never see a limit on that. There's no number specified. The only thing I see is in Section 4 on the next page, where we define who the ex officio folks are. And you've got basically 3 categories of people that can be pulled in there. And it's the second category, Part B, where there's saying that the chair of the Board of Trustees shall appoint at least one, but there's no limit. So that, to me, it's just confusing because we really don't have any definition of how many. I mean, could there be a dozen additional people appointed? Is it just one intended to be appointed by the chair as their representative? Or so anyway, I think that raises the issue. To me, it's unclear what our number is. How many of us are there? Is there a cap on it? And does this mean the director can appoint as many as they want? Because I did see also that there's a new provision saying that the president of the college can remove anybody at any time for any reason. So to me, it's just not clear. We have these folks because I know we had a committee that was talking about how are people elected and brought onto the board. But then there's this other provision that allows people to be appointed, and it seems like it's an unlimited number. And then also a provision that says anybody can be removed for any reason. So just thought I'd raise that because that's the first place it comes up. It's on page 1.
And I had the same concern.
Ditto.
Yeah, Madam Chair, would you like me to
Yes, please.
address? So you're correct, Director Balot. To give you some context of that provision, that language exists in Florida statutes, in the Florida Board of Governors regulations regarding direct support organizations, and in the new College of Florida regulations regarding direct support organizations. And so that language itself, we left alone in terms of the chair of the Board of Trustees' ability to appoint ex officio members, because that comes from statute, BOG regulation, and new college regulation. We could not, as a foundation board, legally change that provision, even if you wanted to. It's comes from a higher authority 3 times over. And so you're correct. It's the chair's prerogative on how many and to what extent. She's required by law to appoint at least one. So that's the minimum. But it's really the chair's prerogative on how many the chair wants to appoint, when or if at all, beyond the one required.
But I'm confused, and we did have this confusion when we were going through candidates. And we were surprised, frankly. And so you mentioned about following the UF and USF path. What do they say? Because I thought UF was 1.
They have UFs, it's 1.
Yeah, so they can do 1. I think that's their practice. They have a number of other, like their provost and several other of the university vice presidents are also ex officio members. And typically a lot of their voting is done by those members, not the members at large.
Could I ask, I guess, is there any distinction? I mean, once somebody has been appointed on, either they come on as sort of what I'd call the normal process, which is they go through vetting and, whether they're then elected to the board or they're directly appointed. Either way, once they're director, they each get a vote, is that right?
Correct. So the
So there's no
ex-officio
difference in
director-
status once you're on.
Once you're on, you have the same status as a director, with the caveat being that the ex-officio directors do not count towards the enumerated minimum and maximum director provisions in, I believe it's Article 4, Section. Oh no, I'm looking at theirs. Yeah, Article
They
4,
don't, they,
1.
they aren't counted as far as quorums and things for meetings or
Counted as
votes?
quorum and they're full voting members. And so you're exactly correct. There's kind of your traditional process, which goes and emanates from the foundation itself, that goes through the nomination and governance committee process. And then that's voted on by the full board of the foundation. And then once the foundation, if and when they vote on nominees, those slate of nominees may be presented to the Board of Trustees, and it's only when the Board of Trustees approves them that they become confirmed as directors on the foundation. And so the chair has the prerogative to appoint ex officio ones that bypasses that somewhat lengthy process, and is typically utilized, I would say, in recent times for prominent members of the community and who would serve a strategic purpose of elevating the foundation and its mission and core functions for the university.
And I don't mean to get us off on a big tangent here, but this to me was the only thing that really jumped out when I was reviewing all these bylaws. But I guess so. So there's a process that we go through normally, all right, to appoint somebody, and then even once you go through that process, then it has to still be approved by the director's office, correct? And then for them to be on the board. But then there's this other process you just described where you can bypass all of that and just get appointed directly. And I guess that, and as somebody who was also on the committee that does this vetting process, I think it's very confusing because, we go through this process of trying to identify folks for the board and then, get those folks approved and these people are on, and then suddenly there are people that we're just notified are on. And so I'm just curious, you mentioned traditionally that's just reserved for, special circumstances or all. Is there like a policy or something that tells us how people fit into that category? Because as somebody brand new, I just don't know how that works. And I just noticed, that there were some new appointments. And so it just raised the issue, well, wait a minute, is that a completely different process than what we just did? And if so, how does that work? And is there any guideline for that, or is that totally separate?
Yes, so it is totally separate and under the new college regulations. And so let me take a step back and just provide context, because I don't think that I've done this since you've been on one of the calls, Director Balot. As a direct support organization, it's enumerated and created by statute in by the university to support new college. So it's essentially, think of it, the best way I can describe it, in particular to a lawyer, is think of it as a wholly owned subsidiary of the college. And so under the new college regulations, new college Board of Trustees has empowered the chair through their process to give the chair the prerogative to appoint one or more members to the board of directors as her designee or designees to the foundation board or to any of the other, we have 2 other direct support organizations. And so that's the chair's prerogative to exercise in the chair's discretion. And I would say part of that, it goes hand in hand. Of the chair also has the responsibility under Florida law and under our regulation that the chair actually has to recommend annually a certification that the DSO, each DSO, whether they should continue to exist or not. And so that, I think, kind of goes hand in hand with the discretion and the ability for the chair to appoint members.
You lost me on that last point. So the chair has to do this to make sure it's in good legal standing?
No,
Okay.
no, it's just, my point is
certification.
the chair is given broad prerogative under new college regulations, which authorizes the existence of the direct support organizations like the foundation. And so each year, the chair under Florida law has to recommend certification. So each year, the college has to say, we're going to keep each DSO in existence, or they no longer serve the function of what we want, and we're going to disband it. That's entirely up to the college. And so that's then delegated primarily to the chair. And so I'm just trying to give the committee context of why the chair is given the prerogative to appoint members, is because the chair is largely responsible for those recommendations and the oversight of the DSOs.
Okay. And I think, thank you very much. I think what confuses me is if the DSO does not touch on governance. Because if some candidates, some members of the board are not vetted or run through us, is it, are there, and that is not, it's not.
I am taking a
It's very nice to meet you. I'm saying go after today, it seems like two moving parts.
So I think, again, that would be the chair, in exercising the prerogative, vets candidates, and ultimately the vetting that's done at the foundation level is a recommendation to the Board of Trustees. And so when you're talking about this other process, the Board of Trustees is delegating that prerogative and discretion to the chair to exercise. And so in both paths, it all leads to the Board of Trustees. It's just one, the full board is approving the recommendation from the foundation board, and then down the line to this governance committee, versus when it comes from the chair, they're just delegating that discretion to the chair directly.
Okay.
If I'm reading this correctly, then if you take that provision you just described along with what looks to me like a new provision, unless I missed it somewhere, which says the president can now remove anybody that he wants for any reason. Technically speaking, I mean, the chair could actually appoint every member and remove all the existing members. Is that, I mean, technically that's the way this reads, and that's why it just seems odd. If that's the case, then why do we even have this process to have the board itself vet people and go through all of that?
Well, I think you still have the minimum and maximum caps for the regular board members, and so we would have to fill those through the foundation regardless. There's no ability for the chair to appoint ex-officio members that are then considered as meeting that minimum or maximum cap. And so you still have slates of both types of directors.
I guess what I'm saying is technically, you could have all of the elected directors removed, and you could have 12 to 24 ex-officio appointed people on the board.
No, that's.
No, how? Okay.
But I think what I'm reading is, and we do need to clarify this because it's a sticking point for me too. Theoretically, just theoretically, it gives you an unlimited number of appointments.
Except you still have to
And-
have a minimum of 12 or max of 24. to
Yes,
come
but-
through.
But it seems to diminish the board's I guess I'm gonna say responsibility in, like, it's sort of like, why have a board and a vetting process if the appointments can supersede any number that we have, which makes everything we do feel like we're just going through motions rather than carefully choosing people who would be good stewards of the foundation. And it politicizes the process a little bit, if I can say that. It feels that way to me.
I don't feel it politicizes the process, and I'm sorry, I've been kind of listening in a little bit, so my apologies if I come across too strong. I joked about it last time, right? Our job is to get to 24 as fast as possible. I think some of us heard that, right?
Yeah.
If we do our stewardship the right way, student focus on the young adults and what we're trying to do, I don't foresee any, because that role will change over time. Whoever's running New College will be somebody new, evolution, time, change, people love and do different things. But I think if we're being great stewards and we do our job well, and we represent New College beautifully, in our communities and we focus on what's important, the leadership will recognize that and will not have an issue, right? With maybe adding 1, 2, 3 people, for whatever reasons they have, they personal reasons. But we are the connections to the community. So we that are appointed, that go through this process, the vetting process, we're the community. Most of you guys are alumni, are people who connected to New College and represent New College extremely well through the foundation. So that's how I look at it. I can't worry about what somebody else is going to do. I can only worry about what I control. So from my perspective, what I'm talking about here, and I know everybody's got a comment, I'll finish real quick. So from my perspective, and I'll shut up, is I just want to focus on making sure that when we vet people to come into this group, their heart is in the right place from a point of view of being passionate about that experience that young adult is going to have and the value that they're going to provide to the community and to the world. And I think we do that. And I think we've done that historically. And I'm a victim of that from my daughter and her experience. So I feel, I don't want to go into the weeds anymore, but that's just my opinion. So the wording is the wording, whatever it is, if it's legal and if we're supposed to do it.
Well, I think I agree, and I think we're saying the same thing. I think the only issue is where I'm trying to find out who is doing the vetting. Is it going to be the board that does the vetting of the members, or that to me is just not clear the way it's written. And it may be that it all everything works out and it's been working out fine, but to me the changing in the language is begging the issue.
So I would just say to clarify again, Madam Chair, is the vetting ultimately in either track goes to the Board of Trustees, vets in either event, whether that's through the chair as a delegated authority for the full board, or even the traditional track, the Board of Trustees is still the one that ultimately vets the candidates and approves them. So I think the answer in either track is the Board of Trustees. Does that help provide? I understand the question, and so I think that is the simplest way I could answer.
And I think, David, thank you for saying that, because I think it helps clarify it for me, as well as knowing that the ex-officios, and we need some clarity on the language here, don't count towards that 12 to 24 number. But I do think we need some clarification as it relates to when we say ex-officio with a vote, we're saying the chair of the Alumni Association under which terms they serve. We're saying the president of New College and or his or her designee. So are we also saying it's the chair of the trustees as well as because it just basically says the chair of the New College Board of Trustees shall appoint, but it doesn't say that the chair of the Board of Trustees is a member. So it's kind of like,
it's earlier in there, and that's something that we could have moved, but we tried to also not alter things materially if we didn't have to. And so there's actually another provision in here in section 1. So that was an existing provision.
Just for simplicity and clarity when you're looking at this. And I don't know, again, if it makes sense to, we have at least one, but not more than number.
Can we change that?
Because effectively we have, and then maybe we also need to talk about the fewer than 12, because we run into issues with that. And the last bylaw revision in March of 2023 actually reduced that number to 12. So, I'm just throwing it out there since we're discussing everything, but I do think we need some clarity, and I do see it here, but just for simplicity, if you're focusing on one point of the document, we should make it read more like the other two, A and C, that the chair of the Board of Trustees is an ex-officio director and has the ability to appoint at least.
Agree.
We can move that provision to where it addresses in section 4 the rest of the ex-officio directors. So we could just add probably a new so there would be A, B, C, D.
And there's also a point of clarity for the chair of the foundation is also an ex officio member of every committee,
Correct.
but I don't believe that it specifies that they're a voting member of those committees, so maybe just putting that in.
So
there.
that's, that becomes a fun lesson in Latin. And I would say probably, in nonprofits, the attorneys in the room can probably weigh in on this, is one of the more misunderstood things of ex officio or ex officio non-voting. And so if you just say a position is an ex officio director, that by saying ex officio means they have full-fledged membership rights. So you would have to designate as ex officio non-voting to then remove the voting right of the ex officio member.
Okay, thank you.
But to Adam's point, as far as, maybe there's a minimum, but maybe a maximum, or some kind of ceiling, and like, if UF is allowed to do it, why can't we do it?
So that would be something that would be at the Board of Trustees level, because that's how they have it worded in their regulation as an authorization to the chair. So that would be a question and a policy decision for the Board of Trustees to take up in their discretion, whether they wanted to do that or not.
So it cannot go in the foundation bylaws.
We can't conflict with what the new college regulation says.
But if it's not there, it's not a conflict. If we can add it in our bylaws, and it does not conflict with what's there. Yeah. For comfort, and to get to Jacob's point, which is excellent, we're all here for that reason. But bylaws can try documents to make sure who's over here does it right. Doesn't try to change it. So if we could put some kind of cap, I think that would be really helpful. Maybe it's just selfish, for foundation members of governments, so they don't feel surprised.
Yeah, so I think that's just also, I continue to go back to, just the context of the role and the corporate structure of a direct support organization. Everything flows to the Board of Trustees. And so I would be hesitant to recommend something at a policy level to say you guys could suggest a change. You're free to do that. That's your prerogative. But in my view, as legal counsel, it would be a policy recommendation for the Board of Trustees to consider if they choose to. And I'm not in a position to speak for the Board of Trustees on whether they would entertain that or not.
But you're our legal counsel, right?
Correct.
All right. I mean, and I think what I'm hearing though is just, can we recommend that? As our attorney, can't you ask them to consider that? If it doesn't conflict, I just think it would help make it clear, how this works, if there's some cap or number on it.
Or balance, maybe not,
This DSO does not get to operate as its own completely freestanding entity independent of the College of Florida. Every DSO's sole existence is to support the university for which it serves as a DSO. So those powers do flow from the university, the College of Florida's Board of Trustees, down to the DSO. And by statute, it's written in the statute that if a Board of Trustees does not believe that a DSO is functioning in the best interest or the sole interest of the college, the board actually has an obligation to shut it down. Now, we didn't do that, okay? And everybody's worked very hard for very long for New College with this foundation. But we are talking about fundamental functioning of a foundation that sole existence is to support New College of Florida. So that's the mission. That's what has to be done. And whatever these bylaws say, that's where everybody needs to be directed, is to supporting New College of Florida.
And I don't see what we're saying as being inconsistent with that. We're simply asking if that's something that the board would support, because I think it helps provide clarity. I don't think it's in any way inconsistent with what you just said as well.
Let me suggest something. When I first saw this, I was very much opposed to it. Then I did the research, and David is right. The statute says at least one. The regulation, New College regulation says at least one. I think there is potentially, I think everybody here has raised the good argument of, well, could we impose a limit as long as it's at least one? It sounds like UF has a limit.
Yeah.
I don't want to get bogged down in this, because I think we need to get these bylaws revised for this year, because we've got so many other things to move on to deal with. But I do think it would be worth, after, if we pass these bylaws, to take another look at this and see what the best practice is among the other state university system institutions. And we can always come back and offer another bylaw amendment in the future, whether we do that, through the foundation board, or we do that as a suggestion to the trustees. I'm open to that. I think we've raised some good questions about, if there are no limits on this, what could it look like? I personally think there are a lot of good reasons to have something like this, because, if all of your volunteer directors suddenly leave, and, you need a functioning board, you need a backstop so that somebody can appoint board members so the organization can keep operating. So it's not that there's no good reason for this. But what I'd like to suggest is that we recognize that the statute requires what the language that David has put into or really was there before, that the statute requires it. Let's move on and then come back and look at this in terms of suggesting a potential limit, but not make what we do today dependent on that. If that makes sense.
I agree, Jim. Monica, you had your hand raised, and then I think we are probably going to move on.
Well, first of all, I am concerned about this issue, but I think what Jim said is excellent, and we move on, and if we can, we come back. I'm really talking about Section 3, the powers. And look, I'm on the advancement committee. Yeah, it comes right after Section 2 is term limit and Section 3 is powers. I am concerned in the advancement committee that, and I think we want the board to work on donations, raising money, doing those things. And of those who have the experience, it takes a village to get that done. I was with an organization for 10 years, and we worked with the city under the sunshine. I was part of the foundation. We raised $10 million, which came through totally with no challenges, but it took a village. My point is, if I can't call anybody, and does Section 3 mean just the board and all the committees that I have to be part of I have to have permission to notice it, and I can't call Jim, or I can't call our board chair? I don't know how we can raise money. And the other thing is, it is collaborative. And I think our focus has to go back and of raising money. And I think Sydney would agree with it. For example, and I'll be brief, I'm on a board, and there was a couple that he was on the ballet board. She is in the market. And I used to have a friend in New York City. They have buckets and buckets of money. So we set up a dinner with the CEO at a club here downtown at the Yacht Club, and they connected, and they're giving. And that's, in a way, how giving happens. It happens through the president, it happens through the board, etc. So I need clarification. And I asked Dave, if I'm on the governance, on both the governance and advancement, and I have a hot prospect, I can speak to Sydney, but it takes a village of other board members to close a big deal. So it says in here that we can't notify anybody unless it's noticed. I can't pick up the phone and call our chairman of the board or Jim, who is the head of advancement. So I need some clarification about that.
Yes, Madam Chair. So Monica, your question's well taken, and I understand the frustration, and I would agree that from a policy standpoint, it makes things difficult to operate. That being said, that provision is really just to encapsulate and document the board's requirement to comply with Florida's sunshine law requirements, which is essentially is exactly what you're talking about, is preventing one or more than one board member from communicating about business that could be before the board. And so that does obviously impact the way in which you go about fundraising. And you're right, that the proper course is to then, communicate to Sydney, and then Sydney can, go through the proper channels to either disseminate information, or if necessary, in a way that does not violate sunshine law, or if necessary, call a public meeting for the purpose to discuss those things. But those are requirements set forth by the Florida legislature that we're required to comply with. I understanding full well that it makes things more difficult, but we go through this at the Board of Trustee level with faculty committees and other standing committees of the university. Is it makes things more difficult, but the policy is there to ensure that decision making and the operations are in the sunshine and are transparent.
Well, Dave, I agree to disagree for this sake. I've been involved in boards, and they've been in the sunshine. And at the end of the day, Sydney and her team will do a very good job. But closing a deal, I'm not talking 10,000, 15,000. I'm talking about 100, 200, 300,000. It takes the board member who makes the introduction, and then that person brings in the guns to be at dinner, be at lunch, and to sell this. And I'm just saying that we used to make a joke, and you guys are going to shoot me, that lawyers can break the deal. Lawyers are very important to us to protect us, to do the right thing. But on the other hand, they can kill a deal. And I wonder if we can find some compromise.
Monica, Monica, this isn't part of our bylaws, though.
It's in section 3.
Yes, but we do have to follow sunshine law, and I don't think we can't circumvent that in our bylaws.
Well, what I'm trying to say, I've been with organizations who had sunshine, and this is a conservative approach. That's all I'm saying. It's a very conservative approach, and our attorneys are trying to protect us, and we appreciate that. But I don't know how you're going to raise big money with these barriers.
And just as a comment, and correct me if I'm wrong, David, we can have conversations amongst each other, just not about topics that may come before the board. And I fail to see how luring in a big donor would ever come up at a board meeting. I've never been at a board meeting where we've had a conversation about targeting donors specifically. So I think it's really the intent of, we're not supposed to be communicating with one another on business that can come before the board.
That's correct. And then we can, I know you want to move on, Madam Chair. Sunshine is very nuanced. And so you can go, if you were having a wine and dine dinner with a prospective donor, that likely would not violate. But if the conversation drifts ever so slightly over the line, you've gone from being compliant to in a second, you're now violating, because if you start talking about things that are before the advancement committee in terms of fundraising strategies or tactics or other things that would be coming before the advancement committee, it is very easy to drift into those conversations. And so this is as much for the protection of the directors themselves as it is the institution, because a intentional violation is a misdemeanor criminal act. Well, so we want to make sure that we have guardrails on there to prevent, inadvertent drifts that are likely unintentional, but very easy to do in the ordinary course of having.
Dave, I am respectful of that, and with respect, I understand that, and none of it, we're professionals. This group at the table and on Zoom are professionally trained people. and we're not going to drift, but we need some flexibility. And I won't, as we say, beat a dead horse about this, but I've never been involved with a board that had such restrictions vis-a-vis raising money. That's all, and I appreciate and respectfully appreciate you listening to me.
Well, Monica, thank you. I do share your frustration with that. It does make it difficult. Perhaps it's something that can come up at a duly noticed advancement committee meeting about how you can handle this particular situation.
Fine.
And David's right, it's very nuanced. There are some things we can communicate, making sure nobody responds back to us as long as it's factual information that we're not voting on. But
well,
let me say this, Susan, I think you have a really good idea. I'm planning to have a kind of a working session of the advancement committee in September or October. And I think that would be the appropriate time to have David come and really address some of these questions in finer detail for the advancement committee, focused on donor recruitment and those kinds of issues. And we'll have some time at that point to work through these questions. I think they're great questions, but I think we need to move on here. We're never going to get this done today.
I agree. And I'm not afraid of a lawsuit being brought against me because of the nuances involved.
And JJ, people that have other.
I don't think we're gonna, if people need to jump off, I do not think we're gonna be able to get through all our bylaw revisions today.
Fine.
JJ, you're leaving? And Rob, you do too? Hey, Rob, can you stay on? I do want to get to the one issue that you brought up, Rob.
I was waving to JJ. I'm still staying up.
Oh, okay.
Thanks.
We did not get to Rob's question. Rob, I think you were questioning section 5 of Article 4. We're still on the bottom of page 2, everybody. And I think Rob, you brought up that a director, the new language is a director, the president of New College may remove from office any director with or without cause. Is that what you were referring to?
I was just curious, if there was I just noticed that was added, and I noticed that there was a similar provision added that the president could remove an officer, but in that case, that has to be in consultation with the board, but a director can be removed without any consultation.
Yeah, thank you. I mean, I would like some
I was
discussion.
just curious why that was added.
So am I.
Currently, I think our bylaws say 2/3 votes of all directors are necessary to remove a director. So now we're giving the president the sole authority to remove with, to me, no due process. And that's concerning to me. Why would we do that? It doesn't seem like good governance to me.
What does UF or USF?
Both have, the president has the authority to remove.
They do not.
For
'Cause
unacceptable behavior.
for cause, any director may be removed, University of Florida, for cause,
Correct.
But not
without cause. So some of the concerning language to me is without cause. It gives them sole discretion to dismiss a director without any due process. And
So-
Can we just avoid that?
yeah, can we just strike that?
But I think just for clarification, the way that University of Florida defines for cause means actions or omissions that may adversely reflect on the interests or reputation of the foundation or the university as determined by the university president after consulting with the executive board or its authorized designee acting as a senior executive of the foundation.
Yeah, that's good.
Any such determination may be made by the university president at any time and need not depend on the conclusion of any external determination or process. So I wanted to, it's not a matter of due process. That's a defined legal term. It's essentially in a number of the DSO bylaws because the president is charged by the Board of Trustees to ensure that everything is operating, it's utilizing the university's name, trademarks, and reputation. And so the president's ultimately responsible for that. And if you think about the requirements of the existing bylaws, which are that actually emanates from statute. If there's not a provision otherwise, then it goes to a 2/3 vote. But you're talking then about a 2/3 vote in a public board meeting where you're then airing the dirty laundry of, you know, misfeasance or malfeasance of a director, that would then further subvert the interests of the university and its reputation. So there really needs to be oversight and the ability administratively to ensure compliance and that the board's functioning well. And so that's why these other preeminent universities have that authority delegated to the
With
president.
that language, and
Yeah.
so
Mhm.
maybe that, I think there's something in between that just use that same language so that there is some reason, even if it's the president's own reason and that he or she doesn't have to explain it to anybody else. But without cause just sounds mercurial. And if you could just borrow the language from UF, then it shows that this was a thoughtful action.
So I think, you know, we can certainly discuss, and it's the board's prerogative to make amendments, but I would say that is USF has the same thing towards it's not for cause. There's a consultation with the executive committee. But that's even in UF's for cause definition, it's the president's determination.
Sure.
And so there's no added layer of protection when you say for cause or without cause. There's still it's if the president believes there's cause under UF's documentation.
I guess I'm not following that. I mean, by saying with or without cause, I mean, this is expressly saying there can be absolutely no reason. And I thought what you just read has a definition of what cause is. So why can't we just incorporate the definition of cause? Because if you're putting in or without cause, it's suggesting you're pulling in something very different from the definition that you were just reading from.
Yeah.
Otherwise, they wouldn't have defined it as cause. I mean, there's either cause or without cause. So I'm just not. Why can't we just use the same definition? If they're saying that's what cause means, you know, that they're for cause, by putting in without cause here, we're pulling in and we mean something other than that.
Well, I would like to make a motion on that then, because I want to keep moving things along. I would like to amend section 7, please. Oh, sorry, I'm wrong. I'm looking at UF's bylaws. Where are we? Section 5 of Article 4. I would like to change that sentence that the president may remove from office. Sorry, I'm getting my documents up here.
Without cause.
No, it has to yes, without cause. I would like to remove without cause. The director may be removed with okay, oh, I'm sorry, last sentence, sorry.
Yes, you're
The president of New College may remove from office any director with cause. So I'd like to amend the bylaws to state that. Do I have a second?
I second that.
Any more discussion?
I'm concerned about that without defining cause more specifically. That could potentially lead to litigation and disputes and things. I mean, are we talking about cause in a corporate sense, you know, corporate board dismissal sense? Are we talking about cause?
Well, did we just hear that there was a cause definition in some Florida statute? Couldn't we refer to that as defined in Florida statute, whatever that was that we were just hearing from?
No, that was the UF bylaws. I mean, I think if you're gonna say with cause, then I think you need to define cause so everybody understands what it means. Otherwise, it's just gonna lead to more commotion.
Yes.
So how do we proceed here? I have a motion on the table. I'm not comfortable with the without cause language. There is a second. Do we want to vote on this, or do we want to add what the definition of cause is here?
I
or
think
reference.
procedurally what you could do, Madam Chair, is vote on the motion on that's before you that has a proper second. And then if that passes, then I think it'd be proper, if it's the committee's desire, to entertain a separate motion on any definition of cause.
That makes sense, yeah, because you have some language to pick. Just see US.
So based on this discussion, the motion is to amend this sentence to say the president of New College may remove from office any director with cause.
Jinx votes no.
We'll do a roll call, Katrina.
Yeah.
Yeah,
roll
we'll do a roll call. Deb James,
No.
Adam Kendall,
Yes.
Susan Burns.
Yes.
AJ Jansen,
Yes.
Mike Ron,
No,
Charlie Christie
That was my phone.
Fitzpatrick,
No.
Rob Bilott,
Yes.
Hazel Bradford,
Yes.
Jim McDonald,
No,
Monica Van Busker.
Yes.
Unknown caller.
Six yeses and 4 noes.
Thank you. Now, do we need an amendment now that
You're not gonna
describes what
fix that
causes?
now.
What?
We're on time now. This meeting was
Well-
noticed from 2 to 3,
Okay.
so.
Yeah, I
We
think
need
we're
to-
out of time.
Okay.
So,
But it would simplify it just to say CUF language.
no, you can't do that.
No, you'd have to
These are bylaws.
incorporate it.
well, if we have to end the meeting right now, why don't we just wait until the next meeting and David can work on this and come back with some proposed language? I'm really hesitant just to grab the UF language on the fly like this. That's,
Also
I
because
think, a
it's not-
dangerous thing.
I agree.
I think it takes some thought and maybe a little research to see what the other universities are doing. So we don't create a bigger problem here.
I agree. Thank you, Jim. Can I also request that if there are, if you have the state statutes and the DSO regulations, for, just to help us clarify and understand the ex-officio language, that would be helpful.
Mhm.
So if we could have that as a committee, please, I'd appreciate that. And I guess we'll be setting up another meeting, to go over these bylaws. That means we will not be able to vote on this at our next board meeting. But I thank you. This was these were really thoughtful discussions. It shows that we care a lot about New College and the foundation and how we are governed. And I really appreciate everybody putting this much time into it. Jim, thank you so much.
Jim, thank you.
Really, and David, thank you.
You took one for the team, that's
Yeah,
for sure.
thank you so much.
Yes.
Gonna be the most unpopular guy in the room.
No, you're not.
We appreciate you.
All right, thank you, everyone. This meeting is adjourned.
Thank you.
Thank you.